The Scottish Sentencing Council commissioned this podcast to hear what people with knowledge of the justice system had to say about the sentencing process in Scottish courts. During the podcast, we refer to a fictional but realistic scenario involving a character named Andrew, who has been found guilty of a serious assault and is due to be sentenced by a court sheriff. In this fictional scenario, Andrew struck his neighbour Chris on the head with a baseball bat in a planned attack, causing severe injury, after Chris complained about Andrew's loud music late at night. Andrew has a previous conviction for assault, but has since enrolled in an anger management program. The people you will hear have been asked to consider this scenario to help illustrate how the sentencing process works in practice. The views expressed are not necessarily those of the Council. We begin by hearing from Sheriff David Young. How does he begin by deciding upon a sentence, and what are the steps involved?
So I normally sentence offenders in the sheriff court. That can be up to 1 year in prison if I sit without a jury, or up to 5 years if I sit with a jury. I also sit in the High Court for a few months a year as a temporary judge. The maximum sentence there is life imprisonment. Each time I decide a sentence, I follow a number of steps. These steps are set out in guidelines set out by the Scottish Sentencing Council and approved by the High Court.
Sentencing guidelines helps victims and their families understand what might be considered when courts make the decisions around sentencing. It also helps them to understand what to expect from the outcome.
The aim in having sentencing guidelines would be to give the public some predictability about what sentence is likely to be handed down at the end of a case.
One of their main objectives is to achieve consistency in sentencing. They are not rigid rules to be applied without any thought being given to the whole circumstances, but they do assist the sentencer in understanding the sort of aspects of the case which need to be considered.
The first step in deciding on a sentence is to decide how serious it is. This involves assessing the level of blame or the culpability of the offender. You also have to consider the harm that's been caused. And in some cases, you consider the harm that might have been caused. Culpability involves a number of things. For example, did the offender mean to cause harm? Did they plan the offence? Even if they didn't actually mean to cause harm, were they reckless about it? Did they not consider whether harm might have been caused? I think about the offender's age or their level of maturity at the time they committed the offence. That applies even if they come to court many years after the offence was actually committed. If Andrew had been under 25 at the time he was found guilty by the jury, I'd also consider his age as set out in the Sentencing Young People guidelines. Traditionally, judges have sentenced young people differently from older people. But now we have expert research that shows that young people continue to develop intellectually and emotionally until they're aged about 25. There are many different types of harm. There could be harm to an individual or to property. There could be harm to society or to the environment. I'd want to know whether there's a particularly serious physical or psychological effect on the victim.
We spoke to Kerry Knox, who works for Victim Support Scotland.
In some cases, victims can submit a statement that details the level of harm that's been caused to them. For families bereaved by crime, they can also submit a statement about the harm that's been caused. In Chris's case, a victim impact statement might include the injuries that's been caused, the loss of earnings due to stopping working, and also the emotional impact, like not being able to leave his house, feeling unsafe in the community, or being scared to be left alone at home. Victims like Chris may be entitled to compensation through a national scheme run by the Criminal Injuries Compensation Authority. The court should always take the victim impact statements into account when making their decision about sentencing. It helps the sheriff understand the level of harm. But often families and people and victims tell us that sometimes that they feel that their voice hasn't been heard and their statement hasn't been considered. Organisations like Victim Support can help provide assistance to prepare these statements.
In this case, the injury that Andrew caused is serious. A more serious injury generally makes the sentence more severe. If Andrew had been a young person, I would take his maturity into account when considering the level of blame. But his maturity would not affect my consideration of the harm that he caused. I move on to consider the sentencing range. The Scottish Sentencing Council is producing a number of guidelines for particular offences. Some of these will include sentencing ranges. These set out the range of sentences within which the sentence for a specific offence should fall. This means that I'm not tied to a specific sentence, but I can take into account the particular facts and circumstances of the offence that is before me. The next step is to consider whether there are any aggravating or mitigating factors. Aggravating factors can make an offence more serious, mitigating factors make it less serious.
We spoke with Professor Beth Weaver, an expert at the University of Strathclyde, to find out about the role of justice social workers.
Justice social workers are independent of the court, and that is the sheriffs, and that's the judges. And they're asked by sheriffs and judges to provide a report which gathers information from a range of sources to provide information on different elements and different aspects of the individual's life, their offending history, their offending behaviour, and any risk of harm they may pose in the future. And the idea is to inform the sheriff or the judge's sentencing decision. In the case of Andrew, we'd really be looking into what happened that brought him to the attention of the courts and the criminal justice system. That means that when we interview Andrew for the report, we would be gathering information from a range of different sources, as well as from Andrew. We'd be asking him all sorts of questions about his offending behaviour, about his lifestyle, about his background. So that could be education or it could be employment. And about his current circumstances, his housing, his family relationships and so on. All of this enables us to make an assessment about what we think might happen next with Andrew, but also how we might best support Andrew to stop offending in the future, but also to protect the public from anything Andrew might do in the future. Towards the end of the report, we go through the various sentencing options that are available to the judge or to the sheriff when they're thinking about how best to dispose of the case, and that means to impose a sentence. And so we go through each of those sentencing options, and what we do is say whether or not we think that Andrew is suitable for those particular sentencing options, or how he's likely to respond to those through the lens of whether or not it will help him stop offending, safeguard the public, and so on.
Julia McPartlin works in the courts as a defence solicitor. We asked her to explain what is meant by a plea in mitigation and what relation it has on the sentencing process.
A plea in mitigation would be tendered where a person is either found guilty or pleads guilty, and it is the defence agent's opportunity to present the client's circumstances to the court, and in particular to highlight anything which would be mitigatory, so anything that would serve to persuade the court to lessen the sentence that they have in mind. And that's the first time the court will really hear about the person behind the offence and maybe some of the reasons for why it happened or any particular difficulties that they might have. It would also be an opportunity for the defence agent to ask the court to deal with the case in a manner that is lenient, but also there may be aspects of the sentence which could serve to rehabilitate the client if there are particular difficulties. In Andrew's case, it's probably quite important that he has taken the step of enrolling in an anger management class, because that shows that he has some insight into the root of his offending. He is also taking some responsibility for that. And I suppose one could imply from that there's a degree of remorse as well. So that's something that we'd be keen to highlight to the court as something positive, something that should be taken into account in mitigation.
In this case, Andrew has a previous conviction for assault. That would be regarded as an aggravating factor, and that would make the sentence more severe. On the other hand, the pre-sentence report says that he is already enrolled in an anger management course. This means that he is taking steps to address his offending behaviour, and that could be regarded as a mitigating factor. Once I've considered these factors, I need to decide what is called the headline sentence. This is the sentence that I reach at this stage, but this may change because of other matters that I must consider by law. If Andrew had committed other offences as well as this one, such as assaulting a work colleague, both charges might be brought to court together. If the offences were serious enough for me to consider a prison sentence, I could give him 2 separate sentences, one for each charge. These two sentences might run one after the other. These are called consecutive sentences. Or they could start and run at the same time. These are called concurrent sentences, which result in a shorter time in prison. The final sentence must be fair and proportionate. That means I have to consider the total sentence overall when deciding on the sentence for multiple offences. The next steps don't apply in every case. In this case, Andrew was found guilty by a jury.
Alex Prentice works as a prosecutor. He discussed how the outcome of Andrew's sentencing might be affected by a guilty plea.
If Andrew had pled guilty to the charge against him, then evidence would not be led because there would be no trial, and it would be the responsibility of the prosecutor to present a narrative of the facts and circumstances for the court to consider.
If he had pled guilty, the law says I must consider reducing his sentence. This is because an early guilty plea saves time and money on the court process. It allows other cases to proceed more quickly, and it saves victims and other witnesses from coming to court to give evidence. The maximum reduction for a guilty plea is 1/3 of the sentence, but this usually reduces as the case goes on. That means that a larger reduction is available the earlier the plea is given.
Andrew pled not guilty to the charges against him, and the matter proceeded to trial. That meant that the judge heard all the evidence in the case, and the jury heard the evidence, and the jury made a determination that he was guilty. The judge must proceed on the basis of the jury's verdict. So if the jury deleted something from the charge, then that deleted aspect could not be taken into account by the judge. On the other hand, the judge heard the evidence in the case, and applying the jury's verdict would take account of all the evidence and sentence accordingly.
Here's Julia McPartlin again.
If a person has been held on remand, so held in prison whilst awaiting the outcome of their case, then the court would take that into account. For example, if they were to be given a custodial sentence, then the sentence would be deemed to start from the date that they were remanded, so it would be backdated. And now there will be some accused persons who, when they first appear, will be released on bail, but with an electronic monitoring order. It's what's referred to as the tag. It's a curfew. Any time that's been spent on that curfew can also be taken into account when it comes to sentencing the offender.
The final step before imposing the sentence is to consider what are called ancillary orders. These orders are imposed by the court in addition to a sentence, or sometimes as an alternative to the sentence. Some of these orders are required by legislation, but others depend on the circumstances of the particular case. For example, in Andrew's case, the prosecutor might have asked me to consider imposing a non-harassment order to prevent Andrew from harassing his neighbour. Now I can impose the final sentence, and when I do that, I will state the general reasons why I arrived at this particular sentence. The guideline that sets out the steps that judges must follow is only one of the guidelines that applies. There's also a guideline on the principles and purposes of sentencing which judges must follow. A sentence may have one or more of a number of aims. In Andrew's case, he committed a serious assault, and I'll consider which of these purposes apply. If Andrew had been under 25, I'd consider the Sentencing Young People guideline. I have to consider all these guidelines alongside each other when reaching a sentence and decide what weight to give to each of them. But these are guidelines. That means I can decide not to follow them. But if I don't follow them, I must state my reasons in court.
What sentence would you give Andrew? Let us know your view, and then find out what sentence a sheriff would give Andrew in different scenarios. Go to scottishsentencingcouncil.org.uk/sentencing process.